Ah, stream was deleted on LinkedIn. Oh, fuck. Hang on. Edit. Sorry, hang on. What's this saying there? For fuck's sake. Looks like the stream was deleted on LinkedIn. Who deleted that? Edit. It's not deleted. Oh, sorry, guys. Sorry. 2 seconds. It's saying that the stream's been deleted. I don't know why that is. Sorry. 2 seconds. Let me just see what. Edit. Oh, fuck's sake. Why are you being like this? Go. Sorry. Oh, fuck's sake. Sorry. Okay, I'm just gonna have to read this quickly. Delete. Oh, that's so annoying. Why did that? Sorry, this is what happens when you have too many people organising stuff.
Okay, don't worry.
Oh, wait. Oh, we're live. Okay, bye. Hello, good afternoon. Sorry, having technical issues as always, but thank you for joining us for the next Essential series. Really delighted to be joined by Stephanie and Olivia from Kingsley Napley, who are going to provide an overview on what can be done and to protect property during a typical life cycle. So we're going to be looking at anything from life's ups and downs, whether it's a relationship breakdown, loss of mental capacity, or death, specifically in relation to property, as this is generally the person's most significant asset. So I'm just going to welcome the girls in. 2 seconds. Hello, Steph. Hello, Olivia.
Hi.
And I am just going to remove myself and I'll let...
Thanks, Lottie. So by way of introduction, I'm a solicitor in the private client department at Kingsley Napley. I specialise in estate planning, tax and trust advice, and the administration of estates. My clients are generally mostly high net worth individuals, but from a range of different backgrounds and sectors. Often they have an international dimension to their affairs. I'm joined today by my colleague Olivia, and I'll let her introduce herself so I don't miss anything.
Hi everyone, I'm Olivia. I'm a solicitor in the family department here at Kingsley Napley. I specialise in all aspects of private family law, including relationship and marriage breakdown, pre- and post-nuptial agreements, domestic and international disputes over arrangements for children, and also family formation, including surrogacy, donor conception, and all things modern families. And that's me.
So as Lottie said, today we're going to look at how a property can be protected through a typical life cycle. And we're mainly going to focus on the family home, but some of what we say applies equally to any property interest. A property is often the most important or valuable asset that a person owns. And for many of our clients, it often holds personal or sentimental value as well. It's therefore one of the main assets we find that clients are keen to protect from any threats that may arise in the event of a relationship breakdown, divorce, loss of mental capacity, or death. So Olivia is going to look at the family law angles of property ownership by cohabiting couples and married couples, and how a property interest might be protected in the event things go wrong in the relationship. Whereas I'm going to focus mainly on the equally unhappy topics of a loss of mental capacity, death, and what planning can be undertaken to protect a property in these situations. Whilst we're focusing on property, some of the things we talk about could also apply to other assets that individuals are keen to preserve and potentially pass on to other family members. So maybe, Olivia, you could start by looking at the earlier part of the life cycle where a couple is thinking about moving in together or just finds themselves living together.
Sure. So as Steph mentioned, I'm going to start off by talking about property rights and protecting those property rights in a cohabitation scenario or situation. So the first thing to note is that there is a fairly widespread misconception or misunderstanding about the rights of cohabitants under English law. Many people understandably, but wrongly, believe that couples in a committed relationship who have lived together for a certain period of time accrue rights and would have some form of financial claim against their cohabitee, arising purely from their status as long-term cohabitants. That's not the case, and there is no such thing in this jurisdiction as a common law marriage. There are no specific financial protections in place for cohabitees, but rather they must rely on or borrow from other areas of law in order to find remedies or solutions to the issues that they face. This could be a claim in property under the Trusts of Land and Appointment of Trustees Act to assert an interest in a property that you have lived in together or that you financially contributed to. Or if you have children, a claim on behalf of your child or children for maintenance or financial support to provide a home for that child during their minority. Cohabitants therefore have to rely on this patchwork of other legislation and remedies to find solutions. These are not cohabitee specific and therefore don't necessarily provide a full solution to the various issues which can crop up on a relationship breakdown. And I'm just going to ask Steph to kindly move me on to the next slide. So where the law is lacking, clients look for other bespoke solutions which can help to provide a bit more certainty for their futures, whatever they may look like. And they look for ways in which they can tailor those solutions to the specific requirements of their personal relationships and circumstances. Enter stage left, the cohabitation agreement, or if you are feeling particularly loyally this lunchtime, then the cohabitation contract. And we use those terms interchangeably, they mean the same thing. These are documents or agreements which set out the parties' intentions. They can confirm ownership of certain assets or properties, which may in practice have a shared use during the cohabitation. The agreement can be clear about who owns what and in what proportions, and also what happens to that asset on a relationship breakdown. You could also include provisions which set out how the relationship finances will be regulated during the relationship, such as will there be a joint account, who will contribute what to it, who will be responsible for mortgage payments or bills or other shared expenses. The document can also look forward to future events, such as starting or expanding a family with children or moving home. While it is possible to crystal ball gaze to an extent, it's often better to review and update an agreement in light of a change in circumstances. So if you entered into a cohabitation agreement early on in your relationship and things change along the way, it's a really good idea to review that agreement and update it accordingly. Much in the same way with prenuptial agreements, people feel uneasy about discussing what would happen on separation when they're in a happy relationship. And what I would say is if you can get over that sort of initial awkwardness, then having those discussions up front really brings those knotty issues which may arise on a separation to the fore. And it's generally much better to be discussing them while you're in a happy relationship rather than waiting until a rainy day comes and you are separating, as attitudes can often harden and people are often not at their most reasonable or constructive when it comes to the time to separate. If a cohabitation agreement does not extinguish disputes altogether, at the very least it should have the impact of reducing them significantly and therefore reducing any sort of fallout or heartache and time and expense litigating matters afterwards. So in terms of how you can use these documents to protect property, you can make declarations of ownership in respect of property. So in the document you would confirm who owns what and in what proportions or shares. So it's really clear at the outset who owns what. You can also exclude the other party from asserting a beneficial interest in that property. They may contribute financially or in other ways to the property during the course of the relationship, and then seek to claim a beneficial interest in it. This can be excluded at the outset and effectively shut down that potential line of litigation, which makes for a cleaner ending should a rainy day come and a separation happen. You can also provide certainty over who will pay what bills, including the mortgage, and set out clearly what impact that has on the ownership of or any claim for beneficial interest in the property. So someone later on down the line can't say, well, I contributed to the mortgage, so therefore shouldn't I have some kind of claim on the property? You've been really clear about it from the outset, so everybody knows where they stand. And while we would encourage parties entering into a cohabitation agreement to declare their property interests in the agreement itself, we almost always advise that this is backed up and supported by a simple declaration of trust, which deals with the legal title and beneficial interest in the property only, and can be registered at the land registry as a restriction on the title. Parties may also want to consider a will, which sets out how property is to be treated on their death. These agreements can be entered into in anticipation of cohabitation or during a period of cohabitation. There's no sort of time limit on when they can be entered into, so any time is a good time. And just moving on, we're already on my next slide, that's great. Thank you, Steph. As I mentioned, these agreements are more often than not being negotiated in happier times than is the case on a separation, unless you have a very civilised separation, in which case I applaud you for that. It's no mean feat. It's really important to capitalise on the fact that there is a good relationship at the time the agreement is being negotiated, and also to do for the lawyers or whoever else is involved to do so in a way that is consistent with and respectful of that existing relationship. And I find that this type of work lends itself really well to more collaborative methods of working, such as agreeing the terms of the agreement in mediation. So the two parties would appoint a mediator and, with the mediator's help, discuss and agree the terms of the agreement, the mediator taking the role of facilitating that agreement rather than telling the parties what to do. Or the other option is collaborative law, and the clues in the title a little bit there. The party solicitors agree to work together in a specific way, which eschews that stereotype of lawyers batting terms back and forth and is a generally more harmonious way to work, which is often in keeping with the status of the relationship between the parties at that stage. Looking now at the formalities, the document will need to be prepared and signed as a deed. Each party should have independent legal advice, so even if they're in mediation, they would have lawyers in the background to help, once the terms are agreed, to help draft the document. And the terms of the agreement should be reasonable. The document is entered into by the parties and intended to be legally binding. And taken together, these formalities give the agreement the best chance of being upheld. There is not a great deal of case law at all on cohabitation agreements. However, the consensus is that if the terms are reasonable, the other formalities have been met, and there is no public policy reason not to, then the parties are likely to be held to those terms. Finally, turning to the issue of reform. So this is an area which is ripe for reform. The number of couples in cohabiting relationships has increased hugely, and it is now reportedly the fastest growing form of family in our society. Our legislation is not kept up to date at all, and as you will see, there are significant gaps, and so there's no real legislation there for cohabitants. The gaps which exist have a disproportionate effect on women from ethnic minority backgrounds, and there was a report that discovered this in 2022 on the rights of cohabiting partners. And following that report, there really seemed to be some momentum to get things changed and to reform the law, but that has really waned and appears to have fallen down the government's agenda. The report recommended two different types of models, so either an assimilation model where the parties who have cohabited for a certain period of time and meet other qualifying criteria are treated as if they were married, or a difference model, which essentially says there'll be a new law enacted to provide specific financial rights for cohabiting couples as distinct from married couples, recognising that different choice that they've made. There's a real push and campaign by family lawyers and academics to update the law, and it's an area where reform is clearly needed, so watch this space. And on that note, I will hand you over to Steph, who's going to talk about declarations of trust.
Thanks, Olivia. So declarations of trust are one of the things that Olivia mentioned. It's something that as a private client lawyer, I'm often asked to prepare with a view to protecting the financial contributions that parties have made to a property purchase. So quite often it will be where there are two or more purchasers who are contributing different amounts to the purchase. It's quite common for one party to be bringing more to the initial financial contribution, perhaps covering the deposit, sometimes with help from their parents. And often it's actually the parents who are encouraging their children to take steps to protect the gift that they've received in the event there's a relationship breakdown. A declaration of trust is a really useful self-contained place to record a number of things in relation to the property in the hope of avoiding disputes further down the line, or having to find and rely on some form of trust in order to assert your rights in the property. A declaration of trust can cover a number of things, which a few of them I've listed on the slide there. They can cover initial financial contributions from each party, how they intend to meet any mortgage payments going forward, how general household outgoings will be met, what should happen if one party decides they want to sell the property, and this might in turn include provision for how the property should be independently valued, the procedure for letting one party have an opportunity to buy out the other, the time frame for putting the property on the open market if one party decides not to buy out the other, and finally, how the net proceeds should be divided following a sale. A declaration of trust is very much focused on the property alone and the financial considerations relating to that property. If therefore you were looking for something a bit more all-encompassing and or not just restricted to the financial aspects, a cohabitation agreement may be better. That being said, I appreciate that a cohabitation agreement may not be suited to everyone. And one of the benefits of a declaration of trust is that it can quite easily be tagged on to the conveyancing process. And some of our clients find it easier to think of it as a contract or commercial document rather than making it feel too personal or like it stems from a lack of trust in the other party or a lack of confidence in the relationship. And another benefit of a declaration of trust is that as far as legal documents go, it can be drawn up relatively quickly and at a fairly low cost. So I'll hand back to Olivia now, who I think is going to look at marriage and what might be done to protect a property in the event of a divorce.
Thanks, Steph. So turning to marriage and seeing my enthusiastic caps lock in my slide. So marriage really does change everything. When you become married, you effectively create a whole raft of financial claims which can be activated and made upon a divorce. It's very different from cohabitation, where there are no relationship-specific rights or protections, as we discussed. If you are married and then divorcing, your potential claims are vast in comparison. Before it's decided who gets what on a divorce, the first exercise is computation, which is a neat way of saying what assets are there. So once you know what there is, you can then start to sort those assets into two piles. So you have matrimonial assets on the one hand, and those are assets which are built up or acquired during the marriage, and then non-matrimonial assets on the other side. So those are assets which emanate from sources outside of the marriage. Sadly, it's not always as black and white as that, and there are many shades of grey in between, as you can imagine. But using the family home as an example, and a little bit of family lawyer shorthand for you here, the FMH, which stands for the former matrimonial home. This is more than likely going to be considered a matrimonial asset, even in situations where one party has funded the purchase, or it is in their sole name, or in the name of a company in which they are the sole or majority shareholder. The courts are fairly resolute in their view that this is a matrimonial asset by virtue of it having been the family home. They sort of say, that's where your married life has been. Could it be any more matrimonial, to borrow a term from friends? And the courts will often say that the former matrimonial home has a special character as a result of this. And then looking at what orders the court can make. Well, there's a few different ones in terms of properties. So they can make an order for sale. So they say the property has to be sold and the proceeds are divided in a certain way between the spouses. They can make an order for transfer, so transferring from one spouse to another, or from joint names to one of their names. Or there's another option for a deferred order for sale. So this allows one party to remain in the property for a certain number of years, after which the property is sold, and then the proceeds can be divided at that point. Often that can be the case when there are young children, and so one of the spouses will be allowed to stay in the property with the children until a certain trigger event, so the children reaching a certain age, and then they either have the option to buy out the other party's interest, or the property is sold then and the proceeds divided. Just pop over to the next slide. So how does a court decide what order to make? So the court looks at what we call the Section 25 factors, and these are the things which it needs to bear in mind and take into account when exercising its discretion. So these factors include the ages of the parties, the duration of the marriage, the financial resources, earning capacity, any contributions made to the welfare of the family, the standard of living enjoyed during the marriage, and so on and so forth. There's plenty of them. At the top of the list of those factors is the welfare of any children, and the court is really clear that this must be the first consideration when they're deciding who gets what. Another key Section 25 factor is financial needs. Ordinarily, this means the party's reasonable housing need, so the need for them to have a home to live in, and their income needs, so what they need in order to meet their regular outgoings, need to trump everything. And so where one party has a greater need than the other, or is less able to meet that need from their own resources, then they may well be entitled to a greater share of the matrimonial assets in order to meet that need. A court will also look at the other party's assets, including non-matrimonial assets, not necessarily to share those non-matrimonial assets with the other party, but as a sort of backup or financial cushion to a party who may be awarded a lesser share of the matrimonial assets. The court will know that they have other assets or resources waiting in the wings available to them to meet their needs. So even if they get a lesser share of the matrimonial assets, they will be okay and able to meet their needs using those other resources. Finally, the structure of the settlement is likely to be important. Rarely is the case that we just chop everything down the middle or sell everything and divide it by two. We look at creative ways of structuring a settlement so that assets can be kept and things don't necessarily need to be sold if they don't need to. If a family home can be kept for one of the parties and they want to keep it, then the court will try to do that and be creative about how that happens. And just moving on to the next slide. So in terms of protection, there is the availability of pre- and postnuptial agreements where you have the ability to ring fence assets and say that they form part of your separate property, which is not to be divided on a divorce. There's a bit of a health warning to be had here around ring fencing and family homes in particular, because the ability to do this will really depend on the financial context of the marriage. There is going to need to be sufficient wealth or assets to allow for a property to be ring fenced for one party, and there's still to be enough left to meet the other party's needs, including their housing needs. Often with your sort of everyday divorce, you're trying to squeeze a budget for 2 new homes out of one. The parties are separating and they each need a home. And so there will need to be a certain level of wealth to ensure that the existing property can be ring fenced and the other party will still be able to meet their housing need. As before, it all comes back to needs. And if the ring fencing of that asset will mean there isn't sufficient to meet the other party's housing needs and their needs generally, then the prenuptial agreement is unlikely to be upheld and therefore unlikely to be effective in terms of its ring fencing of a family home. There are various formalities which apply for prenuptial agreements, which I won't go into now. However, the key one here will be looking at everyone's needs and ensuring that the prenuptial agreement does not have the effect of leaving one party in a predicament of real need. That's it from me on marriage and prenuptial agreements. I'll hand back to Steph now to discuss capacity and powers of attorney.
So having made it through a relationship breakdown unscathed or been fortunate enough to have a happy and successful relationship, the next consideration in our life cycle is a loss of mental capacity. With people living longer nowadays, mental capacity is becoming more of an issue. And from a practical perspective, when someone loses capacity to make decisions for themselves in relation to their property and finances, it can result in difficulties and delays in getting things done. That's why we usually recommend that when thinking about estate planning as a whole, anyone with assets in the UK considers putting in place a lasting power of attorney or LPA for property and financial affairs. This is something that we should all be thinking about, but it's also particularly relevant for our parents or elderly family members who perhaps haven't really thought about this themselves. In an LPA, you choose individuals called attorneys who you want to step into your shoes and make decisions for you in the event you lose capacity and are unable to make decisions for yourself. So in a property and finances LPA, this would include things like liaising with banks on your behalf, ensuring household payments can keep ticking over, and in a more extreme situation, selling your property if you were moving into a care home, for example. Without a valid LPA, if you lose mental capacity and no one was legally authorised to step into your shoes, it would be a case of someone applying to the Court of Protection for a deputyship order to be made, authorising someone to act on your behalf. This isn't generally ideal, though, because it is a more costly and time-consuming route. The key decision in an LPA is choice of attorneys. It's not necessary to include professionals or anyone with particular skills, although in the case of the property and finances LPA, it can be quite helpful if the person does have an aptitude for managing finances. But the key thing above all is appointing people you trust. It's important to note that attorneys in a property and finances LPA are not empowered to make gifts of money on your behalf or to just give away your assets, nor are they permitted to mix their assets with your own assets. They're required to try to help you make a decision where possible, as it's acknowledged that capacity is fluid and can come and go. Attorneys are also reminded in the LPA itself that they cannot treat you as not being able to make a decision just because they think it's an unwise decision. You can include in a property and finances LPA any preferences or instructions as to how your attorneys exercise their powers. So you might want to provide some guidance on the more significant decisions like selling your home. So quite a common one that I see is clients asking for wording to be added along the lines that the family home shouldn't be sold unless it was absolutely necessary as a last resort in order to meet health and care costs. If an individual has quite extensive guidance, it's usually best to keep this out of the LPA itself and in a separate letter of wishes. In order to be valid, LPAs need to be registered with a government body called the Office of the Public Guardian, or OPG, and the OPG can take issue with LPAs where they think it's seeking to impose too many restrictions on how an attorney can act. If an individual has lost mental capacity while their LPA was in the process of being registered, unfortunately, it is just a case of waiting, which can take months. But I have had a few cases recently where the delay in registration of an LPA has held up a significant event like the sale of a property. And in that case, I have found that the OPG are willing to expedite the registration, even though they don't advertise that as a thing that they do. So in summary, having a registered property and finances LPA in place means that things can keep ticking over if you were to lose mental capacity, including any payments, contracts, or sales in connection with your property. So moving on to the final stage in our life cycle, I'm going to talk about what happens to property on death and how your wishes in respect of any property in your estate might be safeguarded. So if you die co-owning a property, the first consideration is whether you co-own that property as joint tenants or tenants in common. If you held as joint tenants, your share in the property will pass automatically to the surviving co-owners, irrespective of the terms of any will you may have and whether you're married or in a civil partnership. If, on the other hand, you hold the property as tenants in common, you'll be treated as having a distinct share in the property, which passes on your death not to the surviving co-owner, but according to your will, or in the absence of a will, according to the intestacy rules. A joint tenancy does keep things simple if you're of the view that on death you'd want your share in the property to pass automatically to your co-owners. Many people prefer, however, to exercise more control over what ultimately happens to their share, and in this situation it makes more sense to hold as tenants in common. You can easily check the property title at the land registry to see whether you hold as joint tenants or tenants in common. And if it is the former, it's very easy to sever the joint tenancy so that you each hold distinct shares. We quite often prepare simple one-page notice of severance to deal with this. If you die owning a property or a share in a property as tenants in common, it is important that you have a will to determine who the property should pass to, as without a will, you're relying on the intestacy rules, which doesn't always lead to the outcome that you may want. It's a particularly ideal relying on the intestacy rules if you're in an unmarried relationship and you want your partner to inherit the property. As Olivia's touched on, there's no such thing as a common law marriage, and without a will at the moment, an unmarried partner will receive nothing from your estate. So preparing a will should generally serve your wishes much better and provide you with more options. There are a few ways we tend to deal with property interests in a will, so I'll just run through those in the final few minutes we have. The first option is simply providing for a property or share in a property to pass outright to a chosen beneficiary. This is clear and simple, but it doesn't provide any degree of asset protection. The recipient can do what they want with the property, including sell it or rent it out. It also means that that property and its value could be vulnerable if that beneficiary goes through a divorce, for example. The second option is providing for a beneficiary to have a right to occupy the property, either for the rest of their life, for a fixed period, such as 2 years, or until the happening of a certain event, such as remarriage. At the end of the designated period, you control who the property passes to. The beneficiary's interest is very much linked to occupation of the property only and not the value represented by the property. And you can make clear the conditions of occupation in your will, such as keeping the house in good repair, paying all outgoings. The third option is one we commonly use in wills for married couples or civil partners, and that's a life interest trust. A life interest trust can be restricted to certain assets, like your home, or it can cover all assets in your estate. It gives the lifetime beneficiary a right to occupy any property within the trust rent-free for the rest of their life, or a right to income if the property is rented out. On the survivor's death, the property or underlying capital value is ring-fenced for your chosen beneficiaries. A life interest trust is a good option for spouses or civil partners because it also secures the spouse exemption for inheritance tax purposes, but assets don't simply pass outright to the surviving spouse. And the fourth main option is a discretionary trust. We commonly see this structure in wills for individuals who are not married and want some flexibility in who they benefit from their estate. The main advantage of this structure is asset protection, because the property would be held within the trust, which would be managed by trustees who you choose for the benefit of a class of beneficiaries who may include a partner and other family members. No individual beneficiary actually has an entitlement to assets within the trust, so it provides good protection from the threats of an irresponsible beneficiary, the divorce or bankruptcy of a beneficiary, or influence from any third parties. One of the main downsides of a discretionary trust is cost and administrative burden. The trust is set out in the will, so it doesn't become active until your death. But following your death, the trust enters its own tax regime, and there's a requirement to file tax returns with HMRC and pay periodic tax charges. So it is something to bear in mind and take advice on to ensure it's the right structure for you. So I think that is it from us today. So ultimately, there are quite a few threats to a property interest during a typical life and death cycle, but hopefully we've also demonstrated that there are a few things you can do to try to protect against those risks. Thanks very much, and do feel free to contact Olivia or me at any time if you have any questions. Oh, you're on mute, I think, Lottie.
Sorry, I'm so much better in person than online. So thank you both so much. That was a really comprehensive overview, and it also shows how important it is, because I think when anybody is purchasing a property, it is an incredible investment. And if you're purchasing it with somebody else or you are married, it is something that you go into with really good intentions. But as we all know, people change, circumstances change, and it is so important that you are protecting your interests. So there's a couple of questions that have popped up. In terms of the joint tenancy portion of a property on death, if you're not married, would there be any taxes on receiving that portion of the property or not? You know, if there's any CGT or anything like that?
Yeah, so the main consideration would still be inheritance tax, but ultimately, you know, whether you hold as joint tenants or tenants in common doesn't really matter. It's who the recipient is, essentially. Yeah. So we are in a situation where you're very lucky if you're a spouse or civil partner because assets pass to you tax-free. But if you're, you know, just an unmarried partner or another family member, assets will be subject to inheritance tax before they then go to you, and that would include a share in a property.
Yeah. Okay. So there wouldn't be, so say, sorry, I'm not making it complicated, but like if it wasn't your first property, say you've got a property with your sibling or something as a joint thing, that's not your major, you know, your primary residence. Say your sibling died, you get their portion of it there. It would just be an IHT on your death then, rather than any, you know, I don't know, a stamp duty transfer or anything like that. That wouldn't be an issue.
So as it stands, only inheritance tax is a concern. Yeah. So sibling dies, their estate is taxed and the property will form part of their taxable estate. Property then passes to their sibling. They would benefit from a capital gains tax uplift. So they don't have any capital gains tax to pay. They'll just have to pay capital gains tax in the future when they sell, unless it's their principal private residence.
Yeah, okay, that's really helpful. And I think again on the life interest trust, that would then apply the same if you were gifting that to a child.
Yeah, so it is a bit more complicated from a tax
Yeah.
perspective if you're looking at a life interest trust for someone who isn't a spouse, because you are then in the realms of being within the tax regime, unlike a spouse who's very fortunate.
Well, this is the thing as well, and I think, you started off so brilliantly saying that actually the reforms that are needed to possibly be considered by the government in terms of the different ways that people live, in terms of cohabitation, are not particularly helpful unless you are married, and a lot of people just don't want to be married, so that is almost the cost of not being married. And then I think another one is the responsibility to cover the cost of selling a property on divorce or death. Who does that come to? When it goes into, say, probate or you're separating the property with your ex, who pays and deals with that?
Shall I do the divorce bit and then I'll hand over?
Yeah.
I'll do divorce, you do death stuff.
Yeah.
So on a divorce, typically, whether it's court ordered or you've reached an agreement, which we then put into a document called a consent order, it would provide for the property to be sold and then certain expenses to be met. And more often than not, these are sort of top sliced off the sale proceeds. So you would, if there's a mortgage on the property, the lender is repaid their loan. And then off the top of that, you pay estate agents fees, conveyancing fees, any other fees. If it's not your principal primary residence, you might have some CGT to pay. So usually that comes off the top, and then the proceeds, the net sale proceeds after all those expenses have been paid, are divided. That I would say that is probably 90% of the time. Sometimes there's a different arrangement where somebody says, actually, you pay the CGT, or you pay the agent's cost, but that's fairly unusual, and that would be kind of a specific arrangement or agreement between the parties. But it's all set out in the order, and then the conveyancing solicitor would see the family agreement or the family law order. They'd get the net sale proceeds in. They sort of dish them out to whoever needs them, agents, lender, whoever, and then the proceeds would flow to the parties from there according to the agreement.
Thank you. That's really helpful. And Steph, on your side?
Yeah, on the death side of things, so generally it would be an administrative expense of the estate. That's usually how it would be interpreted. So the costs would come off the pot of assets that are being distributed to whoever the beneficiaries are under the will or intestacy, unless sometimes you get wills where there's a specific gift of a property, and they might say within that clause, we want this gift to bear its own costs, essentially, which would be a bit tricky because they might not have any liquidity to deal with the costs that come with it. So usually it's just covered by the rest of the assets in the estate.
Yeah, that's really helpful. And I think, again, going right back to the start of a relationship, for instance, the declaration of trust is something, as you say, it's very, very useful. Are they is it sensible to then renew that as you're going on? So say someone else is making a greater contribution into the more, are they flexible in terms of what they can do?
They are fairly flexible. So what I have done before is sometimes the financial situation with the property is evolving. So you do try and future-proof it as much as possible at the start. But quite often what I've done is where there are any updates or changes, essentially they get added as an appendix that is again signed as a deed by the relevant parties. But it just then you can look at it as a whole to see original document, and then there've been these further financial contributions, let's just make sure they're noted as well.
That's brilliant. And I guess I don't know if you guys have any closing comments that you'd like to make on maybe like your top 3 things that you would recommend to somebody at each of those stages. So sort of early stage, property owner, substantial, and then end stage.
I think I sort of got one tip actually across all of them, which is just going into everything with your eyes wide open and knowing where you stand. It's particularly with relationships, marriage or unmarried relationships, it's so easy to get swept up in the romance and the happiness of it all. And of course, lawyers want people to be happy too, of course we do, but we want everyone to be happy and informed. And whilst sitting down and talking about these things, or entering into agreement, however you go about it, is not the probably what you want to be doing in those kind of early days of cohabiting, or whatever it is that you're doing. It will really kind of set you up for the future if you go in, if you talk about these issues, sort of lay it all bare as much as you can at the outset, while the mood is good and everyone's happy, and then you really know where you stand. And like I say, you're going into it with your eyes wide open.
Yeah, so wise, absolutely. And anything from you, Steph?
No, I think that summarizes it really. I mean, I think, yeah, just at the outset, it doesn't, it's how the conversation is had, basically. It's not coming from, what if we divorce? What if we have a relationship breakdown? It's just trying to make sure that you're protecting each other, and that, things like the declaration of trust, as I said earlier, see it almost as a commercial, oh, we should just tag this on at the end just to make sure we've made everything clear and covered our positions, and then parents, if they've contributed, they'll be kept happy by this as well. So it's just really about, yes, we're recommending all these documents and things, but it's just trying to have those conversations in the most productive way.
Yeah, and again, talking about maybe parent contributions, loan agreements and things like that, a lot of time people forget to actually document them. And it's very important to document when you are, gifting or loaning. I think people almost forget, because, if it does become a dispute, it's very easy to forget what the intention was. So documenting at the outset is key, and this is something which you guys specialize in, and it's what you do to help. So thank you both so much for such an amazing overview. And anybody who's watching this on replay, again, feel free to reach out to Steph or Olivia if you do have any questions. But yeah, thank you all, everybody, for tuning in. Thank you both. I'll see you later.
Thanks.
Bye-bye.